Let's see. Mr. Kermurthy, were you ready on Mr. Bradford?
Oh, yes.
People versus Bradford, case number 235202. Record should reflect Mr. Bradford's present here in court today.
Here, Cook on behalf of the people.
Thank you, Mr. Bradford. You can satisfy that.
Did receive a police report. Had a chance to review that. So, Mr. Kermurthy, do we have an agreement for no contest?
We do, Judge. Yes, the plea offer is to count 2 and count 4, count 1, and count 3 would be dismissed. And rest, that's what we, but then the reason for no contest is that we have seen liability.
Okay, thank you. Ms. Cook, is that a correct statement of the plea offer?
It is, and count 2 is resisting and obstructing causing injury, and count 4 is domestic violence.
Thank you. Mr. Bradford, have you had a chance to talk to Mr. Kermurthy about this plea agreement?
I have.
Okay, and is that how you wanted to proceed today? Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Bradford, are you currently on any kind of probation or
Mr. Bond conditions, yes.
bond conditions? Okay. You understand that by pleading no contest to count 2, which is assaulting, resisting, or obstructing a police officer causing injury, the maximum possible penalty for that charge is up to 4 years and worth $5,000 fine. And that count 4, which is domestic violence, that's a misdemeanor that carries with it a maximum penalty of up to 93 days and or a $500 fine. With those penalties in mind, what is your plea to those charges?
No contest.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights. I do. You understand that you're giving up and waiving all of those rights by pleading guilty. I do.
No contest.
Oh, I'm sorry, you don't have.
Thank you.
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of the appeal. You understand that? Has anyone threatened you with anything to get you to plead no contest? No. Has anyone promised you anything other than what we said here on the record? No. It's at your own free choice to enter this plea. Ms. Koch, have you reviewed the police report that was provided?
Yes, Your Honor.
Do you agree that it provides the information in there would provide a factual basis to support a finding of guilt as it comes to and 4?
I do.
I do.
The court has reviewed that police report, and I agree that it would provide a factual basis to support a finding of guilt as it comes to and 4. The court will mark and admit that report as Court Exhibit 1 and accept that as a factual basis. Ms. Koch, are the people aware of any threats, promises, or inducements of the place that correct?
No.
Ms. Koch, are the people satisfied that the court has complied with statute for going ridiculous?
Yes.
All right, Mr. Bradford, the court finds that your plea is knowing and voluntary. The court is again satisfied based on the completion of the Court Exhibit 1 that there is a factual basis to support a finding that you're guilty of these 2 counts. The court will accept the no contest plea. We'll set this matter for a sentencing hearing. It's important between now and then that we stay in touch with Mr. Kermurthy so that we're ready to go forward on that day. Before you leave today, you're going to meet with Mr. McFella to set up a pre-sentence interview. The court will also adjourn the trial date currently set for August 15th in light of the plea today. Coach, anything else on this file?
No, thank you.
No, sir, thank you.
Thank you. versus Sarah Nicole Trosper, case number 2453.
Sierra Cook on behalf of the people.
I think you're aware of her resident Ms. Strasburg. She's not.
Okay, Mr. Gerber, how do we want to proceed on this file today?
Judge Ms. Strasburg will take advantage of the plea offer tendered in this matter. She will plead to an count free possession less than 25 grams. It's 40 felony, $25,000 fine. Count 2 operative intoxicated. Counts 1 and the second names will be dismissed. Also, Judge, she is 74 eligible, so it's not part of the plea agreement, but the prosecutor does not object to 74 status. Putting her on that 74 status.
Okay. And are we taking complete on the actual basis of one?
Yes.
Ms. Coke, is that a correct statement? The offer?
It is, Your Honor, and the PAC code for possession less than 25 grams is 333.74032A5.
All right, thank you. Ms. Strasburg, have you had an adequate opportunity to talk to Mr. Gerber?
Yes, I have.
Is that how you want to proceed today?
Yes,
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Ms. Strasburg, are you currently on any kind of probation or parole?
no,
And you understand that by pleading guilty to this added count of possession of less than 25 grams of the narcotic, that is carries with it a maximum possible penalty of up to 4 years and or $25,000.
yes, I do.
And that operating while intoxicated or impaired as a second offense is a misdemeanor that carries with it a maximum penalty of 1 year in jail and or $1,000 fine. Do you understand that?
Yes, I do.
With those maximum possible penalties in mind, what is your plea to start this today?
Guilty.
Now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand that you have all of those rights.
Yes, I do.
You understand that by pleading guilty, you'll be giving up and waiving all of those rights.
Yes, I do.
You don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of the appeal. You understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what you said here in court?
No, sir.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are guilty?
Yes, I am.
The information I have indicates this happened back on February 19th of this year. Is that correct?
Correct.
On that date that you've been, on that date, did you have possession of some methamphetamine?
Yes, I did.
And did you know what that substance was?
Yes.
Did you have any legal right to any amount of it at that time?
No, sir.
You also operate a vehicle on that date.
Yes, I did.
Drive that vehicle on M93 here in Crawford.
Yes, I did.
The time that you were driving that vehicle, had you consumed a controlled substance?
Yes.
And did that substance prevent you from being able to reasonably and safely operate that vehicle?
Yes.
Had you previously been convicted of operating while impaired in 2018 here in District Court?
I would, yes. I was parked at the hospital and somebody called on me because I fell asleep in my car.
You went to court and
Yes.
you were convicted on that. Ms. Coker, are the people satisfied with the factual basis?
Yes.
Yes, sir.
Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on record?
No.
No, sir.
Ms. Coke, are the people satisfied that the court has complied with statute and court rule and taken that
Yeah, Sean.
Prosper, the court finds that your plea is knowing, voluntary, accurate, or dissatisfied that there is a factual basis to support a finding that you are guilty of this charge or full charges. The court will accept your guilty plea as to both. One last question. Have you ever been previously convicted of a controlled substance?
Never.
So we'll set this matter for a sentencing hearing. You'll be notified of that date and time.
Okay.
As I told the previous person, make sure that you stay in touch with Mr. Germer.
Absolutely.
And then you're going to meet Mr. McDowell here today to set up a pre-sentence.
All right.
Judge, does the court need a separate petition for 74 status, or will that just be addressed by Department of Corrections in the pre-sentence? So,
I don't need you to file anything separately.
okay,
I think that'll be, it sounds like Ms. Trosper is going to qualify based on
correct.
testimony today. So,
Okay. Thank you, Judge.
thank you.
I need a few minutes with Mr. Scarborough, and I just want to make sure you received his updated substance abuse assessment. I just received that.
I did receive it, and I did have a chance to review that over the lunch hour. So
Okay, and I don't know if he's had it yet, so I want to review that briefly. Judge.
all right, we'll take a short recess. We'll come back on the record. in about 2 minutes. We're on the record in People versus Travis Scarboro, case number 235253. The record should reflect Scarborou's present here in the court today.
Sierra Code can be after the people.
We got a regular,
The date and time set for sentencing in this matter, Mr. Scarborough.
Yes, I got it.
Mr. Murthy, as we indicated previously on the record, for get services, is that something that you wanted to add?
yes, yes, please.
I did have a chance to review that. Are there any other additions, deletions, or corrections?
No, Judge.
Are there any challenges to the scoring?
No,
So, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocation today?
Your Honor, everything is contained in the PSI. I mean, he's 40 years old. He seemed to have some issues. He says more with methamphetamine than alcohol, but we're here on the third, operating intoxicated. He's got a lot of things going on in a lot of different places. The recommendation for 9 months with 11 days credit seems appropriate. I did read through the assessment and it adds some more information, but I think the recommendation was appropriate. Thank you.
Oh, Mr. Gerber.
Thank you, Your Honor, Mr. Scarborough is 40 years of age, he's one of the children. Mr. Scarborough indicates that he is accepted now as the Contested County Sobriety Court program. We did submit the alcohol assessment, which indicates, he's got a severe disorder. Mr. Scarborough indicates that his addiction stems from both alcohol and methamphetamine. And again, he's looking forward to continuing with treatment in the sobriety court program. He indicates he has some letter that has got him into treatment.
I had,
Hello,
I'm sorry.
and then we haven't received that yet, but again, I don't know if that's still in the process of being sent to everybody. But again, I would ask a father recommendation. Guidelines is 0 to 9 months, he's done 48 days. I ask you to give 48 days credit and all the rest of the benches to continue with the Contested County Sobriety Court program. And again, he has a benefit with this plea offer. If he's successful, he can withdraw that plea and do an OWI second. If he doesn't, he's going to deal with this felony, and it's going to make life a little harder for Travis. I think he understands all of that. So I ask you to follow up.
Thank you. Mr. Scarborough, was there anything you wanted to say today?
I just wanted to add that I had talked to NMRE the same day I did the assessment with Catholic, actually a couple days before the assessment with Catholic Human Services. And I've also been accepted into ATS over in Traverse City to do a program to them. I had signed the release of information forms. They were supposed to be sent here to Crawford County, one to Robbie, one to Kalkaska, and I believe one to someone else also. And I'm not sure why they haven't gotten here, but that's also an inpatient counseling that I'm supposed to be starting here as soon as I can receive a letter from Judge today, Kalkaska County. Along.
Okay, and we've confirmed that, are you already, have you met with the sobriety court program already?
It sounds like he's going to enter into the sobriety court program.
I had talked to her earlier in the year and she said I am able and eligible to start her program.
All right, do we have anything in writing?
I don't have anything in writing from Ms. Gomez, Judge, but she indicated that if he was sentenced, she would certainly follow up. The only other letter that I had was from Ms. Anderson prior to that, but I don't have anything in writing regarding his admission into sobriety.
Mr. Haven, are you going to be the supervising agent?
I will be. Yes.
You will, okay. So I guess as part of his orientation or, going through his probation orders, I just want to make sure that we confirm that he's eligible for the sobriety court program and that he's going to be going into that program. So can you follow up on that with him?
I'm sorry, Your Honor, my internet was a little bit goofy and you froze up for a moment. But I can follow up with whatever's needed.
Okay, I just want to make sure we're keeping tabs on whether or not he goes into that sobriety court program.
Yeah, I can make sure we keep up with that. And I think ultimately, I think he lives elsewhere, so he'll have to transfer. But yeah, we can keep up with whatever program he's involved in.
I did review the report. I think that the recommendation is appropriate, in particular, the participation in the sobriety court program. So we're going to follow up with that to make sure that you are actually accepted into that program. But I think that would be beneficial to you. I think it would be beneficial to the community as a whole if you're able to successfully complete that program. And so I don't have any objection to holding jail time in abeyance so that you can participate in that, including whatever they recommend, whether that's inpatient treatment or some other program as part of the sobriety court participation. So the court is going to sentence you to probation for a period of 2 years. The court is going to adopt all the conditions in the report for the probation, including participate in and successfully complete sobriety court program through Kalkaska. The court is going to order that you serve 9 months in the Crawford County Jail. You have credit for 48 days served. The court will hold the balance of that time in abeyance to be served at the discretion of either the sobriety court or this court. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, $500 fine. And that's in addition to any costs required by the sobriety court program.
There is a restitution request for 129.
Is that part of the OEYO?
It's, I received that memo as well. I didn't see the PSI, but I didn't know that was added, but that's what it was $129 restitution amount, which is cost of restitution.
Okay, the court will impose that restitution as well. Mr. Scarborough, do you have the ability to seek an appeal of this sentence? And Mr. Scarborough,
Yes, just for the record, Mr. Scarborough has a paperwork with him and the clerk that he prosecuted.
All right, so Mr. Scarborough, it's important that when you're contacted by Mr. Haven, your probation agent, that you follow up with him and that you comply with any requests of his or the sobriety court program. I just want to make sure that you understand that the primary reason why I'm holding this jail time in abeyance is for you to be able to participate in that program. And so to the extent that you don't cooperate or otherwise don't comply, you serve that jail time. Yes.
Procedurally, I have a question. We've never done it this way. He hasn't been accepted yet. At least I have no information. So is he released today and then hopefully he gets accepted? And then if he's not accepted, he goes back and does the 9 months in jail. I'm trying to make notes for what to tell the jail because I don't know what to do with him in the interim here.
Yeah, I'm holding the remainder of the time in abeyance. Mr. Haven's going to follow up as a condition of the probation on the sobriety court program with Mr. Scarborough. If it turns out that he's not eligible for the sobriety court program, then Mr. Haven, or if he's not accepted into it, Mr. Haven, I would just ask that you notice the court, notify the court so that we can set it for a probation review hearing, and then we may have to modify his probation or do something different at that point. But he will be released today under Mr. Haven's supervision on probation.
Okay.
In a housekeeping matter, when you did the motion for revocation of bond, there was also a bench warrant that is still active. Would you please sign that roll call?
So the court will recall that. Did Mr. Scarborough receive any tolerates?
Judge, he signed those, I have those. It's copy.
And he has his copies as well, Judge, yes.
All right, again, Mr. Scarborough, follow up with Mr. Haven. Good luck to you.
I will do. Thank you very much, Your Honor.
Thank you.
Like, when I get released.
Right, Chair, must be going to transfer that. That goes back to my. The original extra call mistake.
Mr. Murphy, have you had any contact with Mr. Funk?
Mr. Who?
Dustin Funk?
He should be our judge. I'm just gonna check and see. Give me 1 second. Judge. Yeah, well, Judge, Mr. Funk doesn't hear well, so he does read lips. So he can, do you want one of those?
Okay, Mr. Funk, are you able to hear me okay?
Yes, sir.
We're on the record in People versus Dustin Funk. This is case number 245296. Mr. Funk is present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Hope on behalf of the people.
And you're ready to go to Mertz on behalf of Mr. Funk, who's just saying.
Mr. Funk, did you have a chance to go through the pre-sentence report and talk to Mr. Murphy about that?
That's the probation officer?
Your attorney?
Oh, the report that was submitted by probation, do you remember reviewing this report?
I went over with the probation officer, I think.
Do you want to have a chance to go through that with Mr. Murphy before we get started today?
Well,
It's up to you.
it's okay.
Mr. Murphy, are there any corrections that need to be made to that report?
No, Judge, it's just the misdemeanor report.
Okay. Ms. Cope, do the people have any corrections?
No.
Ms. Cope, anything on behalf of the people for allocution?
Yeah, I think the recommendation is appropriate. I'm glad we were able to resolve this matter. I'd ask the court to follow the recommendation. Thank you.
Thank you. Mr. Murphy, anything on behalf of Mr. Funk today?
Judge, I would just ask that you follow the recommendation. Mr. Funk indicates that he would like to set up a payment plan that finds and costs in this matter. He hasn't been in trouble since 2019, which was, it looks like it's from Ohio and it's child support related issues. And again, Mr. Funk admitted to his wrongdoing in this matter, so I ask you to follow this recommendation.
Thank you. Mr. Funk, was there anything that you wanted to say today?
No, sir.
Okay, I did read through the report. I'm familiar with the issue that brings you before the court here today, as well as your background and your circumstances. And I think the recommendation of probation and fines and costs is appropriate in this case. I hope that you understand that if you're going to have controlled substances, you need to have a valid current prescription for those things. And you need to be able to verify that with police officers.
Yes, sir.
And otherwise, you run into problems like this where, it's an issue that doesn't have to be an issue. If you're carrying your prescriptions in a legal way that you're required to. But for that reason, I don't think that jail time is appropriate and the court is not going to impose any jail here. The court is going to place you on probation for a period of 1 year. Court is going to adopt as the conditions of the probation, all the terms listed in the report. So your agent will go through your probation conditions with you. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $50 state cost. Is there a supervision fee on this? Mr. Haven, is there a supervision fee?
Yes, it would be $30 a month.
Okay, and a supervision fee of $30 per month while you're on probation. And you can make arrangements with the clerk's office next door to pay those fines and costs, okay?
Okay.
Because this is a misdemeanor, there are no written appellate rights, but Mr. Funk, if you wanted to seek an appeal of the sentence, then you would need to file for your appeal within the next 21 days. If you have more questions about that, then Mr. Germer will be able to help you with that. Do you have any questions at all?
Oh, no, I don't, sir. Thank you.
All right, thank you. Good luck going forward.
Thank you so much.
Our next hearing is set for 2:15, so we'll take a short recess until that.
Thank you.
Actually, Mr. Trush, it looks like Mr. Ashton is connecting, ready to go forward on that case. Yes. All right, sir, are you Aaron Ashton?
Yes, I'm here.
Okay. All right, we're going to go on the record in People versus Ashton. This is case number 245305. The record should reflect that Mr. Ashton is appearing today by Zoom by prior approval of the court. If I could have counsel put your appearances on.
You're welcome to ask the people.
Thank you.
All right, this is the date and time set for sentencing in this matter. Mr. Trush, did you have a chance to go through the report of Mr. Ashton?
I have had a chance to go through it and I provided a copy.
Mr. Ashton, did you have an adequate opportunity to speak with your lawyer about the pre-sentence report?
Yeah, he sent me a message on that. Yes, sir.
Okay. Mr. Trush, are there any corrections that need to be made to that report?
No, Your Honor.
Ms. Cope, if you don't have any corrections to that report.
And I would ask that the machete be forfeited, but other than that, no.
Anything on behalf of the people for allocation today?
Your Honor, Mr. Ashton comes before this court. He has some pretty old criminal history, nothing recent. He has earned his plea offer, and I would ask the court to follow the recommendation. Thank you.
Mr. Trush, anything on behalf of Mr. Ashton today?
Your Honor, I don't think there's a lot to say on this particular case. In terms of what the prosecutor said, and I agree there's some history that's old here. The circumstances of this offense, I think, are such that the plea offer made sense. The recommendations here, I think, made sense. All things considered, so I would ask the court just to follow that recommendation.
Thank you. Mr. Ashton, was there anything that you wanted to say here today?
No, Your Honor. He said it all for me. Thank you.
All right, thank you. Mr. Ashton, I did have a chance to review the pre-sentence report, so I'm familiar with the circumstances that bring you before the court here today. I'm also familiar with your background and your history as well, based on the information in that report, as well as your current circumstances. And I think given the nature of the underlying crime, as well as your actions subsequent to your arrest, I think warrant the recommendation, and the court finds it reasonable and well tailored to this case. So the court will follow the recommendation and sentence you to fines and costs on this matter. The court will order that you pay a crime victim's assessment of $30, court costs of $325, attorney fees of $350, and a $50 state cost. The court will also order that the weapon that was found in this case be forfeited. And Mr. Trush, is there anything else that you need to address other than appellate rights?
I don't believe so.
Ms. Pope?
No, thank you.
Mr. Ashton, you do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file for an appeal within the next 21 days. If you had more questions about that, you would be able to contact Mr. Trush. He would be able to explain that to you. Otherwise, Mr. Ashton, you need to contact the clerk's office here in Crawford County to make arrangements to pay those fines and costs. Do you have any questions at all?
No, Your Honor. Thank you.
I also wanted to, I neglected to state this, but there is 1 day of jail credit, so the court will send you to 1 day in jail with credit for 1 day served. And that's all for the hearing today, Mr. Ashton. You're free to disconnect at this time.
Thank you very much.
Our next hearing is with Ms. Schweizer at 2:30, so we'll take a short break until that time. On the record, Christine Schweizer, case number 2352228. The record reflects Ms. Schweizer's present here in the courtroom today.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Ms. Schweizer.
Thank you. Ms. Schweitzer, did you have a chance to go through the report that was prepared with Mr. Trush?
Yeah, somewhat.
We need more time to do that before we go forward today.
No, I think I understand.
Mr. Truce, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
On behalf of the people for allocution.
Ms. Schweizer has not done very well on her probation. We've been in and out of the court with her. The recommendation is unsuccessful discharge from probation. Court fines preserved, 210 days in jail with 78 days credit. I think that's appropriate. Ask the court to follow the recommendation. Thank you.
Mr. Truce.
Your Honor, in regards to the recommendation, 210 days, it seemed harsh to me, given that these represent her first felony charges, her first felony probations, her guidelines were 0 to 17 months. I would suggest to the court a more appropriate sentence is probably closer to 90 days or 120 days. Again, just given the lack of history. So I would ask the court to consider sentencing in that range.
Thank you. Ms. Schweizer, did you have any statement that you would like to make?
No, I just kind of was busy and preoccupied. I was trying to get my dog back, which I was able to do. And then I was trying to keep up with going to my NA and 8A classes and trying to find stability. And then I started finding work under the table, helping advice with cleaning up the trailer park. And I thought that was a good thing to do. I was still there. So I just got really overwhelmed and some stuff. So it was just hard. I was trying to deal with staying sober and just trying to get my head in and get back to myself. And I just lost track of everything. I apologize for
Great. I did read through the report, so I'm familiar with your performance while you were on probation. I also read through the underlying PSI from your original sentencing, so I'm familiar with what originally brought you before the court. Of course, I presided over the hearing on your probation violation. So that, looking at well, you were initially sentenced to, essentially, 90 days. You had credit for 54 days at the time, and probation. You did not perform very well on probation. That, as you're well aware, you picked up extra charges now as a result of this violation as well. I do think that a sentence within the original guidelines is appropriate. I think a sentence in the middle of those guidelines, which I believe was 0 to 11 months originally, and 0 to 17, is appropriate to address both underlying conduct as well as your violation conduct. So the court is going to sentence you to 180 days in the Crawford County Jail. You have credit for 78 days served. The court is going to discharge you unsuccessfully from your probation. Given the nature of the violation in this case, the court is going to preserve the outstanding fines and costs here, which I believe are all of the ones that were originally proposed. And again, I didn't say you are going to be discharged unsuccessfully from your probation. You do have the ability to seek an appeal of this sentence. Mr. Schweizer's doing that. Mr. You had a chance to speak with her about how you want to proceed on the felony.
I did it. At this time, we would be asking the court to docket this matter for a trial.
Hope does people need any particular period of time to be ready for a trial?
No, and I know she's not receiving any credit now since she's been sentenced on another matter and she's lodged, so we can be ready as soon as the court gets it on the docket.
How many days of trial do you think?
1.
agree with that?
I would.
And do you need any particular period of time to be prepared for the trial?
Not in particular. I would just indicate to the court, I am on vacation at the beginning of August. I don't suspect the court would docket it that quickly, but if I didn't say anything, it'd be my luck.
Okay. We'll set it for a one-day jury trial. I will have it set for a final status conference to the extent that there are any more different plea offers. Mr. Tricia, are you expecting any kind of motion practice necessary?
Don't believe so.
Ms. Coe,
I do not think so.
what's that?
I do not think so.
Okay, so Ms. Schweizer, we're gonna set that case for a jury trial. There will be one final hearing to the extent that there are any more negotiations or you want to consider any plea offers. That last hearing would be the last day to do that before the trial, okay? Mr. Tricia,
No, thank you.
Ms. Coe,
No, thank you.
thank you, that's all.
Thank you.
So our next hearing is set for 2:45. That's going to be by Zoom. Ready, whatever you want.
Don't.
Mr. Leonardson, which case were you signing in on?
I'm sorry, could you repeat that, Your Honor?
Yeah, what case are you signing in on?
I'm signing in on Copernall versus Petrocinco, the 3 o'clock hearing.
I don't have that on the docket today.
I had secured that information last week. That's fine, but I can reschedule. But there is a time limit, there's a time sequence on this that is being pressed.
Okay, Sarah's looking at the register of actions right now, so 1 second.
Judge, he came in on 6/27, defendant motion for a court order. There was no notice of hearing that was filed. He did pay his motion fee, but did not receive a notice of hearing.
Okay, it sounds like, Mr. Leonardson, it sounds like there was no notice of hearing filed, so it did not get put on the docket.
That too, I thought I hand carried it, but I issued. I guess I'll start over then.
Okay, yeah, I mean, I would start by calling Jennifer, my assistant, and get another date, and then once you have that, file the notice.
Okay. My difficulty is, Your Honor, I'm telling you, I have some problem with opposing counsel and his client. We have a loan assumption document that starts the process that requires the signature of both current owners. And that I need that signed as quickly as possible. There's still a delay in the assuming the mortgage. The second problem is that
Well, Mr. Leonardson, I don't want you to go too far because now we're getting into ex parte communication here, and I can't have you arguing things without opposing counsel here, so I'm gonna have to stop you.
Okay, I'll refile it, Your Honor.
Okay, thank you.
Thank you.
Great, Mr. Zayed, are you able to hear me okay?
Yes, Your Honor.
Okay, all right, we'll go on the record in People versus Laferniere, case number 245285. Mr. Laferniere and his counsel, Mr. Zayed, are present today by Zoom. We have Ms. Cope present here in the courtroom. And this is set for a status conference today. Mr. Zayed, can you tell me where things are at from your standpoint?
Yes, Your Honor, and good afternoon. Justin Zaid appearing on behalf of Mr. Laferniere, who is present to my right. Your Honor, as you indicated, this is the date and time set for status conference on police report. We do have a resolution whereby Mr. Laferniere is prepared to plead guilty to an added count of operating while intoxicated second offense in exchange for dismissal of the original counts.
Okay, Ms. Cope.
That is a correct statement of the offer, and it's contingent on him getting into either a sobriety court or a veterans court. If he's not able to get in, we'll withdraw that. We'd ask the court to withdraw that plea. I did, however, speak to the director of that court. They indicated that veterans court was probably more appropriate because of his background, and I would agree with that. It doesn't matter to me which one he gets into. It's in Waterford. They believe he's been accepted, so we'd ask to do the plea today. We'll be back to sentencing. We'll have all the stuff. We did a MOU and sent it over to them today.
And Your Honor, I can confirm that we have received the paperwork. We will have that executed and sent back sometime today.
Okay. All right, thank you. Mr. Lafreniere, were you able to hear all of that okay?
Yes, Your Honor.
All right, is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So me.
Thank you. You can lower your hand. Mr. Lafreniere, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that by pleading guilty to operating while intoxicated as a second offense, that carries with it a maximum possible penalty of up to 1 year in jail and or a $1,000 fine?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
I plead guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all of those rights?
Yes, Your Honor.
Understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Indicates that this occurred back on August 15th of 2023, so about 11 months ago. Is that the correct date?
That is correct, Your Honor.
On that date, had you been consuming alcohol?
Yes, Your Honor.
And after you consumed alcohol on that date, did you operate a motor vehicle on Highway M72 here in Crawford County?
Yes, Your Honor.
And did you have any blood or breath tests to determine the level of alcohol in your system at the time you were operating that vehicle?
Yes, Your Honor.
Do you recall what the results were?
I believe a 1.7, Your Honor. Or point.
All right, over the legal limit?
Yes, Your Honor.
Do you have any reason to doubt the accuracy of that test?
No, Your Honor.
And do you believe that your ability to safely and normally operate the vehicle at that time was impaired based on your level of intoxication?
Yes, Your Honor.
Had you previously been convicted of operating while impaired back in 2006 in the 97th District Court?
Yes, Your Honor.
Okay, thank you. Ms. Koch, are you satisfied with the factual basis?
Yes, but for the record, the lab report came back at 0.216.
Mr. Zayed, are you satisfied with the factual basis?
Yes, Your Honor. Defense is satisfied, and we will stipulate to the results for purpose of the plea.
Thank you. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, but I would ask that Mr. Zayed, in order to complete the MOU, get the receiving court signatures. Usually the defense counsel does that, so I'd ask that he do that so we can complete the process.
Mr. Zayed, are you able to take care of that matter?
Yes, Your Honor.
Okay. Are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute, the court rule, and taking this plea?
Yes, Your Honor.
Mr. Zayed, are you satisfied?
Yes, Your Honor.
Thank you. Mr. Lafreniere, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. And Mr. Lafreniere, somebody from here in Crawford County Probation will be in touch with you for a pre-sentence report. It's important that you follow up with that when they contact you, okay?
Yes, Your Honor.
Get his phone number, Judge.
Sorry, what's that?
Can you list his phone number?
Sure. Mr. Zayed, can you give us a phone number where probation can reach your client?
If it's easier, Your Honor, I could put it in the chat for your staff, or I can read it out loud, whatever's best for you.
We can just get it now. I've got the probation agent here in the courtroom. He's off
Sure.
camera, but
It is 906-201-2239.
Thank you.
okay, thank you. Mr. Zayed, anything further that we need to address today from your side?
Nothing further, Your Honor. Thank you very much.
Let's go.
Nothing, thank you.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
People versus Coon, case number 2352256. Mr. Coon, if you want to come up to the podium here, please. Mr. Thompson, can you hand Mr. Coon the use the hearing?
Yes.
All right.
Is that a good volume, or do you want me to turn it up?
Yeah. Are you able to hear me?
And now.
All right, good. Okay, so we're on the record. If I could have counsel put your.
Sierra Coke on behalf of the people.
Thank you, Honor. Jason Thompson on behalf of defendant Paul.
29 days.
Mr. Thompson, were you able to go through the pre-sentence report with Mr. Coon?
I was, thank you.
Mr. Coon, did you have an opportunity to speak with Mr. Thompson?
Yes.
Okay. Mr. Thompson, I know there's a lot of information there missing, but based on what is there, are there any corrections that need to be made?
Yeah, well, there's an addition, Your Honor.
Okay.
Under disabilities, Mr. Coon wanted the court to know he is under health. He has heart difficulties and is partially deaf. That leads to him being disabled by the Social Security Administration. He indicated that he let me just check. His heart is operating at lower capacity because of artery disease. So he's working at something like 10 to 20% of the normal heart capacity, and that affects his ability to work.
Mr. Haven, were you able to hear that?
Entirely, Your Honor. Something about heart conditions and partially deaf.
I got it, Judge.
Okay. Mr. McFell indicated he was able to get that information. So I'll just ask if that, I'll ask if that be added under the health section of the pre-sentence report.
Okay.
Mr. Thompson, any other changes?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocution today?
Your Honor, I find this case really frustrating because I think this could have ended in a ticket for something simple. And Mr. Coon has really just made it difficult for himself every step of the way. He had a plea offer to a misdemeanor. Even after he got the situation, then we went to trial. He ended up with a felony. Now he has all these rights that he has lost because he's a felon. Now we're at sentencing. Probably we would have been looking at a recommendation of 30 days at the most, with some probation, but he can't be on probation because he can't cooperate with anybody. So now the recommendation is 6 months in jail with no probation. And literally every step of the way has just been Mr. Coon's own personal difficulties that have caused these problems. This isn't the crime of the century. If he would have just listened to the officers, he would have been fine. If he would have pulled over, he would have been fine. If he would have listened to some of the things his lawyer said, he probably would have been fine. But here we are today, and there really isn't a lot of options because of the situation he's put himself into with his choices. I guess the recommendation is appropriate given his inability to be on probation, and I'd ask the court to follow it. Thank you.
Thank you, Mr. Thompson.
Your Honor, even assuming that that's all true, and I wasn't privy to earlier plea negotiations, but I certainly believe that's possible. Your Honor, even if all that's true, the court has to sentence Mr. Coon on what happened. And the court is very familiar with the facts. The court sat through the trial. The court is familiar with the facts. Nobody's here saying that nothing happened. Mr. Coon's already sat 29 days in jail. I think we're already within the range of reasonable outcomes and punishments to receive from this court. In addition, I know there was reluctance to undertake probation when he initially met with Mr. Haven. After that, I got appointed and I sat down with him and I explained to him what probation was, and that essentially it was voluntary. A defendant can refuse probation, and that can certainly affect what a court does from a sentencing perspective on the other elements of sentencing. He indicated to me that after talking about what probation is, asking me some very good questions, that he is open to probation. He's asking the court to consider probation in this case. I think it would be appropriate for the court to give him 30 days and probation. I think that's within the range of outcomes for somebody who late at night, getting pulled over at their own house, misunderstood the law. He's not a lawyer. He doesn't know the law. He thought he had a right to refuse that encounter. He's wrong. He's been paying the consequence. I mean, as much as Ms. Koch may be frustrated, or I may be frustrated, Mr. Coon is the one paying the consequence. He's the one sitting in the jail cell. He's the one away from his home. He's the one who's lived, he's been deprived. And so ultimately it falls on the court not to, I don't think this is about punishing decisions he made along the way of the case with him and his attorney, whatever may have happened with those decisions. I think this is the time for the court to look at what he did in the world on that night. He refused lawful commands from officers and decide what the appropriate sanction should be. Respectfully, Your Honor, I believe the amount of time he's been incarcerated plus a probation sentence would be within a reasonable range of sanctions for this behavior. So I'd ask the court to consider that. Thank you.
Mr. Coon, anything that you wanted to say today? Obviously, I am familiar with the facts of this case. I watched the videos. I presided over the trial, so I saw all the evidence that was presented. And I think Ms. Koch is correct. You turned what would have been at most a speeding ticket into 2 felony convictions. Not only that, but you turned it into a physical altercation with the officers. They clearly explained to you what the law was that night, that there's a law that says upon request by a police officer, you have to turn over your license, registration, and proof of insurance. For the life of me, I can't understand why you didn't just do that. They explained to you what the law was. What's that?
I thought they were attacking.
They were talking to you for quite a period of time, trying to explain.
I thought they were attacking me, trying to.
I mean, you can say you thought they were attacking you, but I saw the video. Nobody was attacking. They were asking you for your license, registration, and proof of insurance, which you're legally required to give them. And they told you that. They explained that to you multiple times. They told you that was the law. You decided for whatever reason that the law doesn't apply to you. They gave you very clear indications of what was going to happen. You didn't turn it over to them. And you made the choice at that time to ignore what they were saying, to refuse to provide them something that you're legally required, that we all are not just you, everybody. I don't know why you think that you're special and you don't, the law doesn't apply to you when it applies to the rest of us. But you made the choice to disregard their lawful commands. And then when they told you we're gonna place you under arrest, you still didn't provide it, and then you caused a physical altercation where you could have been injured or they could have been injured. All of it just completely unnecessary. Completely unnecessary. You just followed the law. And for whatever reason, you chose not to do that. I don't think probation is appropriate. I don't think that's a good option for you. I think that's gonna wind up getting you into more trouble, probably, than it would do any help. I think a straight jail sentence is appropriate. The guidelines in this case call for a sentence of up to 11 months. I don't think that's called for based on your lack of any prior criminal history, based on the fact that there were no injuries that arose out of this incident. I do think a jail sentence in the low end of the guidelines of 90 days is appropriate. I think it provides a degree of punishment for you. I hope it reinforces to you that in this country, we're all subject to the laws. Nobody's special, nobody's above the law. And that if you refuse to obey the law, even after it's explained to you, there's a consequence to that. So the court is going to sentence you to 90 days in the Crawford County Jail. You do have credit for 29 days served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and $186 state costs, and that's for counts 1 and 2. For count 3, 30 days in the Crawford County Jail with credit for 29 days served. You do have the ability to seek an appeal of the sentence. We're going to provide you with some papers that explain to you how to request an appeal, as well as how to ask for a court-appointed lawyer to help you with any appeal. And Mr. Thompson can provide that to Mr.
Yes, so Mr. Coon, these are 4 copies of your appeal paper. You don't have to file those today, but you have to file them within 14 days. If you fill this out, you can get appointed an attorney and have your appeal filed. You initial the top copy and that goes in the court file to indicate you've received it. It's not the same as filing an appeal. You can take these back to your cell and fill them out if you want to. If you want to file an appeal, you fill these out and they will be mailed to that address. Go ahead and initial there and indicate you received it. Copies are yours if you want to file that appeal. Okay.
That's all for this hearing today. Court's final hearing is at 3:45. Okay, looks like we have everybody connected, and so we'll go on the record now. This is Hamel versus Munson, case number 21-11065. And if I could have all counsel start by putting your appearances on the record, starting with plaintiff.
Good afternoon, Your Honor. Albert Duke appearing on behalf of the plaintiff.
Good afternoon, Your Honor. Bradford appearing on behalf of the EMS defendants.
Justin Hackle on behalf of Dr. Ashton, Your Honor. Good afternoon.
Good afternoon, Your Honor. Good afternoon, Your Honor. James Fritsch on behalf of defendant Eden.
Good afternoon, Your Honor. William Frost, Henless Bronze on behalf of Munson defendants.
All right, thank you. We're on the record here today for Mr. Werda's clients, the EMS defendants, as we'll refer to them collectively, the Houghton Lake Ambulance Authority, Mr. Sproul, and Mr. Kowalski. Mr. Werda, this is your motion for summary disposition as to those clients. I did receive your initial motion and brief. Mr. Dibb, I did receive your response. And then Mr. Werda's reply. I did have a chance to review the facts and law cited by both parties in their briefs, as well as the exhibits that were submitted with the briefs. So today would be the opportunity for oral argument. I will inform counsel that I don't believe that the issue relating to the affidavit of merit, I don't view this in any way after reviewing plaintiff's complaint as claims for some type of professional malpractice against the EMS defendants. So I really see this as an issue of the statutory immunity and whether or not there's a question of fact as to gross negligence or willful misconduct. So with that in mind, Mr. Werda, anything that you would like to present today by way of oral argument?
Thank you, Your Honor. In the Emergency Medical Services Act, the legislature decided to grant immunity to emergency medical personnel. EMS personnel are not subject to liability for medical malpractice. They are only subject to liability for willful misconduct or gross negligence. Willful misconduct is conduct with intent to harm, and even plaintiff's EMS expert doesn't allege that the EMS defendants acted with intent to harm in this case. And so the question is whether the EMS defendants' actions rise to the level of gross negligence. The definition of gross negligence is conduct so reckless as to demonstrate a substantial lack of concern for whether an injury results. And that definition comes from the Governmental Tort Liability Act, and trial courts are instructed to read the EMSA and the GTLA in pari materia. And so the starting point on immunity claims is that the immunity conferred upon governmental agencies is broad. And the Michigan Supreme Court has further stated, quote, the legislature enacted the EMSA in an effort to limit emergency medical personnel's exposure to liability. And finally, courts also note that gross negligence is a much less demanding standard of care. It is as though if an objective observer watched the actor, he could conclude reasonably that the actor simply did not care about the safety or welfare of those in his charge. The undisputed facts in this case fall far short of demonstrating that Chris Sproul and Norm Kowalski did not care about Cassidy Hamel. In fact, they demonstrate the exact opposite. In just a short period of time, 51 minutes, they responded to a 911 call, performed numerous medical procedures, and transported her more than 25 miles to the hospital. And we've provided a statement of facts documenting their actions on an approximately minute-by-minute basis, which clearly shows care for Ms. Hamel, not a reckless lack of care. We've also addressed each one of the specific acts which plaintiff alleges constitutes gross negligence in this case. Many of those allegations are directly disproved by the undisputed evidence in this case. For example, plaintiff alleges that Mr. Sproul was grossly negligent because he did not use an EMG, but both EMS providers testified during their depositions that he did use an EMG. The medical record reflects the exact time the EMG was used, as well as numerous readings from the EMG, that is VFib progressing to asystole and then to PEA. And the medical record also reflects that Ms. Hamill was defibrillated 3 separate times based specifically on the EKG readings. Numerous other allegations are rejected by plaintiff's own expert witness. For example, plaintiff alleges that Mr. Sproul was grossly negligent by not administering amiodarone or lidocaine. But plaintiff's expert acknowledges that since Ms. Hamill did not remain in VFib after the medication port was established, it was appropriate that Mr. Sproul did not administer amiodarone or lidocaine or any other antiarrhythmic. Since we've addressed each one of the allegations of gross negligence in our brief, I won't go into each one today on oral argument unless the court has specific questions regarding any of those specific allegations.
I do not, thank you.
The overarching point then is that even if plaintiff could prove the allegations, which she cannot, they still would not rise to the level of gross negligence. Rather, they would be allegations of medical malpractice only. The allegations generally in this case fit into a few categories. Different medications should have been administered. Different medical equipment should have been used, or the medical equipment which was used should have been used in a different way. CPR should have been performed in a different manner. The transport should have happened more quickly, or it should have happened more slowly based on the amount of time spent doing assessments or taking histories or providing treatments. All of those issues are questions of medical judgment, questions of whether the EMS personnel met the standard of care, not questions of whether they intended to harm Ms. Hamill or acted with such recklessness that they were indifferent to whether she was harmed. We point the court to the case of Castle versus Battle Creek, which addressed just such a situation. In that case, paramedics were faced with a problem with a mechanical ventilator during a transport. And taking the facts in the light most favorable to the plaintiff, if they would have disconnected the patient from the mechanical ventilator and manually ventilated him, he would have survived. They failed to do that, and the patient did not survive. And under those facts, the Court of Appeals affirmed an award of summary disposition in their favor. The court said that the plaintiff's allegations essentially amount to second-guessing their medical judgment, and that such claims do not sound in gross negligence. We'd also direct the court to the case of McLean versus Lansing Fire Department, a case where emergency medical providers similarly responded to an emergency call, found a patient in respiratory distress, rendered emergency medical services, including CPR, medications, and a breathing tube. Similar allegations were made, again, second-guessing the judgments and actions of the personnel, and the court again affirmed an award of summary disposition in their favor because there was not evidence of gross negligence under the broad immunity provided by the EMSA. And then finally, on this issue, we'd also note that the plaintiff has not cited to a single case involving similar allegations against EMS personnel where the courts have found that such allegations rose to the level of gross negligence. I know you've already indicated that you kind of made up your mind on what was our other argument for summary disposition. I'm a little bit surprised at that, candidly, because I thought even the plaintiff's response brief seemed to acknowledge that if there wasn't a statutory separate claim for gross negligence created by the EMSA, that they agreed that there should be a dismissal and that the issue was going to be whether it was a dismissal without prejudice or a dismissal with prejudice. Not knowing your reasoning behind that statement, I guess I don't want to get too far afield, but I would express to the court that that these decisions appear to us to clearly be decisions involving medical judgment made under a contract for all of the reasons that we've cited in our brief. And so, I won't go into them farther because it sounds like the court, doesn't want to spend a lot of time on that issue, but I would be happy to address any questions on that issue.
Yeah, I guess I went through plaintiff's complaint, I think it's a little odd that everybody seems to want to try to guess what plaintiffs are claiming and whether they are claiming a medical malpractice action here that would require filing of a notice of intent and affidavit of merit and so forth. But, and maybe Mr. Dibb will correct me as well, because it's his claims. But when I review the complaint, I did not see, number one, count 2 is specifically pled malpractice, and that's your clients, Mr. Word, are not listed in count 2. They're listed under count 3, which is gross negligence and willful misconduct. They are mentioned under count 1, but always in terms of gross negligence or willful misconduct. So in my view, I don't think plaintiffs have even pled a claim that would sound in malpractice or that would require under the statute a filing of an affidavit of merit or notice of intent. And so, if I don't find that there was an obligation, in essence, I just don't think plaintiffs have arguably pled a claim for that. And so I don't think it would be within the court's authority to issue a motion, to grant a motion for summary disposition on a claim that I don't think has been properly pled against your clients. So I guess that's my rationale. I feel like the real heart of the matter here is the statutory immunity and whether or not the exception has been, there's at least a question of fact of the exception. So
I guess briefly, if I could just respond to that, Your Honor.
Sure.
I would say courts don't look at how the plaintiffs have stated the claim. And so while you're right, they've expressly stated a gross negligence claim. If you look at the case of Kuznar versus Raksha, which is at page 9 of our brief, it expressly says the courts are going to look at the heart of the matter. And then the question is, it's that two-pronged inquiry about whether it arises during the course of a professional relationship. And in this case, clearly any action that the EMS providers undertook was in the course of their professional relationship as EMS providers to this patient, and then whether there was a contract. And that's the whole reason they were there, is that the Houghton Lake Ambulance Authority provides emergency services to residents of this township. But and so I think their labeling of it as a gross negligence claim doesn't change it. It's still a medical malpractice claim, and the EMS defendants do not lose the additional defense, which all medical malpractice defendants have, of requiring an affidavit of merit. There was, in fact, a notice of intent that was filed in this case, just not an affidavit of merit. And so I'll leave the argument right there, Your Honor.
Okay. All right. Thank you, Mr. Dibb.
Just to clarify, good afternoon, Your Honor. May it please the court. Just to clarify, sir, am I to address this issue of whether this is a malpractice case pled or an EMT immunity case? From the courts, at the outset, the court indicated that this was not a question of whether it's a malpractice case, whether it's a case as to whether there's a viable claim under the EMT statute. Is that how?
Yeah, no. And you're free to address the arguments Mr. Word has made on that point. I mean, I just don't think it's, I understand the position, but yes. I really don't think it's been pled here. And I think it kind of illustrates my point, the fact that we're all arguing about what your complaint means. I mean, it's up to the plaintiffs to plead their complaint, to put everybody on notice of what their claims are. And if it takes all of us to try and figure out what you're claiming here, to me, again, that illustrates that there hasn't been a claim for malpractice properly pled here. But
right
I'm absolutely willing to give you an opportunity if you want to address the arguments that Mr. Word made.
I think the court sized it up properly. A malpractice case has not been pled, and to the extent that counsel has claimed on this record that we agreed that this was a malpractice case, that is in error, because at no time did we agree that this was a malpractice case. What we did say was that if the court were to decide that it was a malpractice case, then that we be allowed either an opportunity to file an affidavit of merit or a dismissal without prejudice so that we could refile it in conformance with the malpractice requirements. But at no time did we ever acknowledge that this was a malpractice case. But I think the court is correct. It's a case as to whether the EMT immunity applies and whether plaintiff has pled a gross negligence case. I would submit to the court that this is a fact-specific claim. The deposition of Mr. Richardson, plaintiff's expert, was taken, and he identified 4 areas of gross negligence, which he stated in his opinion were grossly negligent that counsel did not address. The first was the failure to manually displace the uterus to the patient's left during the CPR. That's at Mr. Richardson's deposition, page 111. That, in his opinion, constituted a gross negligence action committed by the first responders. The next was that they failed to place the IV above the diaphragm, which makes a difference in terms of getting the proper medications circulated in the patient's circulatory system to allow an opportunity for the patient to survive. They did not do that. These are facts that are undisputed, by the way. Both defendant first responders admitted that the patient was not, that the patient's uterus was not manually displaced. And they both admitted that the IV was not placed above the diaphragm. The next issue that Mr. Richardson had with the way Kowalski and Sproul handled this emergency was that neither one understood what they were dealing with, that this was a textbook case of preeclampsia, and that they did not treat her for eclampsia. And in fact, reference was made to the textbooks, which they studied and were trained, which specifically described Ms. Hamill as a perfect example of a preeclamptic patient. Neither one of them drew upon their education in the Michigan manuals to train these first responders as to how to handle a case like this. And finally, they didn't transport Ms. Hamill on her left side, which again was another grossly negligent action. Now, counsel didn't address those, and these are fact-specific claims that Mr. Richardson testified to. And as such, we would submit to the court that we have created a genuine issue of material fact on gross negligence sufficient to allow a jury to decide whether or not the defendants were grossly negligent. And respectfully, we would request that the motion be denied.
Okay, thank you, Mr. Word.
If you have any questions, Your Honor, I'm happy to answer any questions.
No, I don't. I thought both parties did a very thorough job of briefing their positions. So, Mr. Word, I'll just give you an opportunity if you had any reply arguments since it's your motion. Oh, you're still muted there, Mr. Word.
Thank you, Your Honor. Let me just address those 4 items that Mr. Dibb just indicated that we did not address. The first one of those was the argument that we were grossly negligent by not manually displacing the uterus during CPR. That's actually addressed at pages 15 and 16 of our initial brief. And the evidence on that, according to plaintiff's own expert, is that EMS providers are limited by the amount of manpower and the amount of equipment that they have on scene. And we specifically asked Mr. Richardson how many medical responders would have to be present before you had a person present to provide left uterine displacement during a cardiac emergency. His answer at page 88 of his deposition was 3. In this case, there were only 2 providers present. The fact that 2 providers could not do the work of 3 does not demonstrate gross negligence. The second issue that it was indicated that we did not address was placing a medication port above the gravid uterus. Again, I direct the court to page 15 of our brief. We specifically addressed it at that point in time and specifically addressed what the medical control authority documents say, which is that an IO may be the first line of choice and that insertion into the medial aspect of the proximal tibia or proximal humerus could be the locations for that. And so they did in fact follow the protocols on that issue. And again, we'd suggest that both of those issues are not issues of gross negligence. They would be issues of medical malpractice, whether the providers failed to meet the standard of care. The third issue that he raised was that we didn't properly diagnose preeclampsia. That was something that came up in their response brief, and so we did address that in our reply brief at page 5. What Mr. Richardson said about the failure to consider preeclampsia was that he would, quote, he would think that they should have suspected it. It should have been in the top 3 or 4 differential diagnoses for sure. And again, that's an issue of medical malpractice. It's saying that my clients failed to make a diagnosis that would have been in the 3 or 4 differentials. And then finally, that we didn't transport the patient to the hospital in the ambulance on the patient's left side. Again, CPR was being administered the entire time to this patient. The American Heart Association stresses that the #1 priority in dealing with a cardiac emergency like this is continuous CPR. And Mr. Richardson expressly testified that CPR manually needs to be done with a patient supine. And so that's how my clients were performing it. It's how they were trained to perform it. And we would again suggest that that doesn't rise to the level of gross negligence. I did just very briefly think of one other thing on the issue of medical malpractice. And that's just, I cited to the cases of Lockwood and Joe on page 11 of our brief. Those were both cases, again, involving EMS personnel actions where the court said that affidavits of merit were required in those cases. And I'll rest right there. Thank you, Your Honor.
May I address that extra issue, Your Honor? Because neither in Lockwood or Joe did they even address the immunity statute. That wasn't even part of the consideration or analysis in either one of those cases. Whatever was alleged in those cases is not what is being alleged here. So reliance on those cases is misplaced.
Okay. All right, thank you. I know that the other defendants aren't involved here, but I do want to give each of the other counsel who are in attendance a chance to the extent that they have any record that they want to make. Mr. Hakala, looks like you're the first one to unmute.
Very nice of you, Judge. I don't have anything to add, though. Thank you.
Thank you. Mr. Frisch?
No, thank you, Your Honor. I don't have anything else to add either.
Okay. And Mr. Fresh?
Nothing to add, Your Honor. Thank you.
Okay. All right, thank you. So again, prior to today's hearing, I had a chance to thoroughly review the briefs of the parties along with the attachments that each side provided. I've had an opportunity to hear the oral argument here today on the record, and it is largely consistent with the arguments put forward by counsel in their briefs. So the court feels comfortable ruling on this issue from the bench here today. Again, as I've indicated, I don't find, reading plaintiff's complaint as a whole and not focusing on the labels that plaintiff uses, but looking at the substance of plaintiff's complaint. And I don't find that they are pleading a claim for medical malpractice such that a affidavit of merit or notice of intent would have needed to be filed. And so I don't find those arguments to be relevant here. What I do find to be relevant is MCL 333.20965. Both parties have cited to that. I think that really controls whether or not the EMS defendants are liable in this case for any negligence in the treatment of Ms. Hamill or her unborn child. That statute, of course, deals with alleged acts or omissions in the treatment of the plaintiff's decedents here. As both parties have indicated, that statute gives immunity to these defendants unless their acts or omissions were the result of gross negligence or willful misconduct. Cases interpreting that statute have found that the purpose of that statute is to limit emergency personnel's exposure to tort liability, and that's Jennings versus Southwood, 446 Mich. 125, 1994. Legislature intended to shield emergency medical personnel from liability for ordinary negligence and to limit that liability to situations where they have been grossly negligent or engaged in willful misconduct. And again, that's Bartolsky versus Osborne, 357, Mishap, 378, 2021. The limits on liability applies only to care that's rendered in emergency situations, and that is what was taking place here. So the court finds that as a matter of law, that statute would apply to these defendants and at the outset would allow for immunity from tort liability for them, and pursuant to 20965 sub 1D would also extend to Houghton Lake Ambulance Authority because that is an entity defined under 333-209-061 that would qualify for immunity under the statute. So the court finds as a matter of law that it would apply to both the individual defendants and to HLAA. So of course, where the rubber really hits the road here is whether or not there is a question of fact as to gross negligence or willful misconduct. Willful misconduct is conduct that's defined by the Jennings case that I previously cited as conduct with the intent to harm an individual. Looking at the testimony of record here, which includes the depositions of both Mr. Sproul and Mr. Kowalski, as well as the plaintiff's expert Richardson, the court finds that there is no question of fact that there was not conduct that would rise to the level of willful misconduct in this case. Mr. Richardson specifically testified that he didn't find that there was any evidence of an intent to harm Ms. Hamill or unborn child. And the court, again, just looking at the testimony of Mr. Sproul, Mr. Kowalski, and Mr. Richardson, in a light most favorable to the plaintiffs, even if all the allegations that the plaintiffs have made were true, and even assuming that Mr. Richardson's critiques of the actions of Mr. Sproul and Mr. Kowalski were all true and correct, the court finds that no reasonable jury could conclude that any of those would result in a finding of an intent to harm. So that moves to the question of gross negligence. And that, as the parties have indicated, is defined as conduct so reckless as to demonstrate a substantial lack of concern for whether injury results. And again, that's set forth in the Jennings case. And so again, looking to the testimony, deposition testimony of Sproul, Kowalski, and plaintiff's expert Richardson, and viewing all of that testimony as the court must in a light most favorable to the non-moving party, to the plaintiffs here. Number one, the court finds that whether Mr. Richardson testified and specifically labeled something gross negligence or not, and it was clear from counsel both sides, they're questioning Mr. Richardson. They were trying to kind of put him in this corner of using legal terms to see if how he would testify. So what he calls gross negligence or doesn't call gross negligence, the court finds is not necessarily controlling. What's controlling is whether his critiques of Kowalski and Sproul, if either any of his critiques, if the court accepts them all as true, would be things that would rise to the level of demonstrating a substantial lack of concern for whether what they were doing would result in injury to Ms. Hamill or her unborn fetus. And looking at Richardson's testimony as a whole, he certainly provides critiques. He identifies a number of different areas where he believes the EMS personnel could have done things differently, things that he would have done differently. He indicates at pages 81 and 82 of his deposition that he doesn't believe that they adhered to the standard of, I know we're using a medical malpractice term here, but I think the intent of what he was indicating is that it was not ordinary care that should have been used. But he didn't testify that anything they did or didn't do exceeded that or went above that. The way he characterized it, and again, this is at page 81 and 82 of his testimony specifically, but I think he mentioned it a couple times when I read through his deposition, is that the mistakes that were made by the EMS personnel, to quote him, didn't provide optimal chances for Miss Hamill or her fetus to survive. And what that says to me is, again, certainly Mr. Richardson had critiques of what those individuals did or didn't do with regard to their care. They could have done a better physical exam when they first got there. They could have taken blood pressure. They could have gotten a better history. All of those types of things, along with the things that plaintiff has specifically mentioned as well. Again, even if they could have done those things, there wasn't anything in the testimony of Richardson to indicate that their omissions or their failures to act or the things that they did that he would have done differently or his opinion that they should have done differently, none of that rises to the level of showing a substantial lack of concern for whether injury would result. Those defendants were providing care to Ms. Hamill the entire time. They were attempting life-saving procedures. Could they have done things differently? Clearly, according to Mr. Richardson, they could have, but they certainly weren't ignoring or failing to give care such that it would be amount to a substantial lack of concern for her. They were giving care that was reasonably related to the symptoms that they were being presented with. Richardson didn't testify that anything they did or didn't do was completely inappropriate for the symptoms that they were observing in Ms. Hamill at the time. Again, Richardson's critiques are all, they should have done this, or they could have done this, or they didn't do that, and they should have done that. But again, I think that all goes to a finding of ordinary negligence, perhaps, but not the substantial lack of concern that would need to be present for a jury to conclude that there was gross negligence here. So for those reasons, and based on the testimony that I've identified, the court finds that there is no question of fact that there was not gross negligence or willful misconduct such that the EMS defendants are entitled to summary disposition under C7 and C10, again, pursuant to the immunity conferred on them by 333.20965. And so, Mr. Werda, the court would ask that you submit an order reflecting the court's ruling today for the reasons stated on the record under the 7-day rule.
Will do. Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. That's all for our hearing today, and all parties are free to disconnect at this time. This also concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.